start off with just a little bit of housekeeping. I'm sure most people are familiar with the remote webinar functions by this stage, but just a couple of things. First of all, this seminar is being recorded and we will be making that accessible to everybody after we've concluded. The second thing is that if you look at the bottom of the Zoom screen, you'll see that there is a Q&A function. During the course of this session, if there is anything that you'd like to ask us, please use that function at any time. We will be able to see it. We're hoping that we'll have enough time at the end of this webinar to answer everybody's questions, but there is a lot of content we've got to get through in a very short amount of time. So if we don't get to your question, we will be looking at them afterwards and we will be answering everybody's questions once we're offline. So please be assured that we will be forwarding this recording and some answers to some questions after we're finished. Okay, so that aside, we'll start off and we'll start with an acknowledgement and then we'll get into the session. So I'd like to acknowledge the traditional custodians of the country throughout Australia and their connections to the land, sea and community. We pay our respects to the elders past and present and extend that respect to all Aboriginal and Torres Strait Islands people today. So we are delighted to welcome you all to our Canaries in the Coal Mine 2022. This is a really important function that we run. It's a great way for us to connect with our external examiners and to provide you with just an overview of what we've observed during the year and hopefully give you some understanding of what we're looking for. If you've ever attended any of our previous seminars, you'll notice that there might be some changes to this particular session. The reason and behind that is that we've had a bit of changes to our functions and our approach. You might have noticed that our team has a new name. It's called the Early Detection and Prevention Team. And I think that's a good thing to start off with because that really highlights the importance of our external examiners. You are our eyes and ears. The metaphor that we use for Canaries in the coal mine is apt for what we're trying to achieve today. So I'll start by introducing the rest of my team who's joining today. So we've got Shalene. And Shalene Smith is our primary contact for external examiners. So she'll be talking today about what we're looking for and how you can connect with her if you do come into any problems during the external examination period. The second person I'd like to introduce is Christine Bell. For our more experienced external examiners, you'll know Christine quite well. She has been with the organisation for 25 years. There is not much that she doesn't know in the way of regulation of trust accounts. And then there's myself. My name is Alice Duggan. I am the manager of the Early Detection and Prevention team. So, when we talk about canaries in the coal mine, we use the metaphor of the first warning signs that something might be wrong within the current circumstances. So this is the importance of our external examiners. What we can't do is underestimate the vital importance that this provides to our next steps. All law practices and barristers classmates have their trust account examined by you every year. The board doesn't make visits to law practices to examine their records without a reason, such as a client has complained or another lawyer has reported a problem. In these cases, our trust account investigators will examine the trust records along with other investigations, but it can't possibly cover the 2,100 law practices with trust accounts in Victoria. So this means that in most cases, you are our only representatives. You are the only people that a law practice will see, and it is important that we hear from you if there are problems. This means not only problems with the trust account records, but it's also issues that we've titled red flags. So how do we support the external examiners that support our work? We want to communicate with you to hear what you see are concerns in the law practice. You are the key investigatory link between the law firm and the board. we want to support you in your role to educate law practices, lawyers about the rules and help them to comply. Your role is also to advise the board about any problems with record keeping so we can decide what regulatory response is best. When you upload the external examiner report into LSB Online, we look for answers that show the rules are being breached. If we identify serious issues, we consider what we know about the law practice and its lawyers. This might include current complaints, matters that the lawyer or their staff has self-reported, the disciplinary history, how they have kept trust account records in the past, including previous reports that you've provided about trust account deficiencies, irregularities, and non-compliance with SDA obligations. We look at their practicing history and we look at what we'll go into further, things called red flags. We engage with the law practice as needed, sometimes by telephone, sometimes with compulsory education. We ask for documents, or we might alternatively send one of our trust account investigators in to inspect the law practice. The outcome might be that everything is resolved, or we might refer this on to our disciplinary team. We might put conditions on a law practice's practicing certificate. We might recommend education. We might recommend that they engage a bookkeeper, or we might take the extreme option of removing their trust account authorisation. The information in your reports is held within our systems for future examinations and is used as part of our data analysis. What you bring to the table is a piece of the puzzle, and it's an important piece of the puzzle that gives us a full 360 picture of what a law practice needs and where the gaps might be in our education. I'll give you an example. We've just had a situation that's still ongoing where an external examiner brought to us some concerns about a law practice trust account. Without that report, we would not have taken some more probing action. That probing action resulted in a trust account investigation. And what that's resulted in is evidence that we will now pursue with Victoria Police that there was a long-standing systemic and comprehensive reporting of the trust account. Without that external examiner's report, we would never have been prompted to take a closer look at this law practice, and we can only imagine exactly what kind of consumer harm would have been done. I'm now going to talk a little bit about, about the challenges that have been faced by law practices and the external examiners in dealing with the COVID-19 restrictions. We acknowledge that the last 2 years has been difficult for the whole society, but in particular, it has caused a lot of issues with law practices giving access to our external examiners and our trust account investigators to inspect their reports. We know that that's been challenging, and we've had many inquiries about how to manage trust accounts clients and the lack of being able to conduct the routine on-site inspections. These issues have included access to records in the office, computerised accounting systems not collecting to clouds, access for bookkeepers to maintain and update records. We understand that there's been a lot of situations where trust account records have not been kept up to date, and we had an unprecedented amount of late lodgement of end of trust year documents last year. In regards to this year and what challenges might be met for law practices and external examiners accessing records, we do prefer that you do attend as much as possible on site. We appreciate that that might not be possible in every situation, and we appreciate that a lot of people have been very agile and very adaptable to the present situation for the last 2 years. However, it remains our preference that you do go on site, but we're willing to work with our external examiners and law practices to do off-site records when needed. If your report does need to be done through an online or remote visit, it's expected that you'd undertake the same testing that you would at a physical visit. Shalene's now going to have a quick chat about the external examiner's course and changes that have happened in that.
Thank you, Alice. So with the external examiner's trust course, this review had taken approximately 2 years to complete.
Sorry, Shalene, I think you might still be on mute.
Can you hear me now? No. Hi, Alice. Sorry about that, everyone. Yeah, just to repeat, the External Examiners Trust course review had taken approximately 2 years to complete. This was completed by the External Examiners Working Group, which consisted of members from Victoria, New South Wales and Western Australia. The External Examiners Trust course was approved by the Legal Services Council, which is the overarching body for the uniform law, on the 17th of December 2021 for a further 5-year review, which will be in 2026. So the course still consists of 12 sessions. However, we've just made the notes section more clarity. At this stage, there's no requirement for external examiners to redo the course at this point. I will now pass on to Christine, who will talk about the external examiners checklist.
Good afternoon, everyone. I hope you can hear me. Thank you for your interest and attendance again this year. We've had a great turnout of participants again this year, which is fantastic. I want to talk about some things just as a refresher from last year, and then I want to introduce a few new topics for this year's discussion. So I did raise last year about our new external examiners checklist, and this had been developed by the bodies within the New South Wales and Victoria, and with some assistance from WA this year as well. And that's assisting the external examiners in the completion of your working papers and preparation for your report. So this was raised at your training course as well. So just to remind you that the checklist provides an easy reference system to bookkeeping practices that are prescribed by the rules and the Act, and it includes a series of tests that help you determine whether there's compliance with those rules. So the tests say, and the screen is a bit small to see, as that's just the subset of the screen, but they're basically a yes, no, NA answer. And a no response may indicate that it's a breach of the legislation, which might need to be recorded in the breaches section of your report. The breaches, all breaches again, as Alice mentioned before, must be reported. So you're required to conduct your normal testing, observation, inquiries to form your opinion as to whether the accounting records have been maintained in accordance with the rules. The use of the checklist, again, is not mandatory. I understand that some accounting firms have their own processes and procedures, but if you don't use something similar to that, you still should be able to demonstrate how you've come to your conclusions and your approach. You should have a similar document that might need to be called on at a later date. The checklist can then be used as your source documents as you prepare your report. So this year the checklist is on our website, and it's in a Word version, and it can be accessed at any time throughout the year. So this year I'm going to go not into as depth as I did last year, but just briefly go through again the things that I'm interested that you could look out for and what not to be overly concerned about. So again, as Alice said, this is the opportunity for you to raise your areas of concern with us, and it is so vitally important that we get the best information from you. As Alice said, we can't get out to every practice every year. So this year we've done a couple of minor changes to the Statement of Trust Money and the External Examiners Report, but they won't affect anything that you've been currently doing. The enhancements, again, have been approved, so they are across jurisdictions, so they are approved every year with the working group that Shalene mentioned on, and Shalene and I are members of the working group. So I raised a lot of these points again last year, but again, I want to appreciate if you could turn your attention to these again. So we have a final comments section. What we can't have is breaches in the final comments. So there is a section specifically for breaches, which highlight the actual breach, the rule, reasons, explanations, everything. If it's in the final comments, it can get lost with everything else, and it's very difficult to pull out and identify those separate breaches. So issues are not being recorded as breaches. Unfortunately, I'm finding some that have been either not included as breaches or have been put in the final comments. So reconciliation's not being prepared, which is the most extreme risk, which I see. Reconciliation's being prepared late. Deficiencies which haven't been recorded as a breach. So any deficiency irregularity, whether it's restored, not restored, fixed, has to be recorded as a breach. Intermixing of trust money and non-trust money. Controlled money where the account hasn't been titled properly. So that would be controlled money or Christine Battling Trust for blah, 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 controlled money account. Statements not being issued at 30th of June. Now, this one that keeps coming up year after year. So I would appreciate that you have a look this year into those statements. The statements are that double check that the client actually gets that the solicitor's holding the correct amount of money for them. So in regard to the deficiencies irregularities, I have done a little bit of work on this year. So when you're preparing your external examiner's report, I did find some examples where the law practice actually said there was deficiencies, but the examiner said there were no deficiencies and vice versa. So when you are reviewing what the law practice has actually had, make sure that if they have said that there are deficiencies, that they actually provide you with copies of them if they haven't already. I know some law practices, as a matter of course, will always copy their examiner in when they notify us of the deficiency. So checking signatories on trust accounts as well. I have had some examples where we have no solicitors, say a non-lawyer, a husband, wife, as the only signature on the trust account, not even any solicitors at all. So ask the law practice who is the signatory on the account. I don't require to see any of the trust account bank statements, or you don't need to cite them. As our system, we get copies of the bank statements every day of total deposits, withdrawals at the end of day balance, and the statutory deposit account. So I had some reports last year that were delayed because the reason was that they were waiting for independent bank confirmation. Well, you don't need to do that. That shouldn't be a reason to hold up your report. If you've got any concerns about that the bank balance doesn't match up to what you're seeing, then you give us a call straight away anyway. Reconciliations not being checked against the bank statement balance. So I've had some where the reconciliations be put together, but they actually don't match up to the end of day balance at the end of the year on our bank statement. So if you could just double check that as well. Again, this is a similar problem that we've had last year, and we've tried to make this a little bit easier. So as you understand that the law practice have to fill in their Part A confirmation, which says which type of trust money that they have. So if they don't say that they have, for say, controlled money, then it will not open those tabs and allow you to answer questions on control money. So if there is you do find that you get to the end and it says that control money, for example, is not applicable, that means that the Part A is incorrect. So once we get the final signed off reports from you, I won't be making any changes after that. So if you think that the Part B or the Part A is wrong, make the law practice go back and start from scratch. They are signing a declaration that it is correct. So I wouldn't expect that they would want to do that, and then you want to certify their declaration as well. Computerized accounting systems is another one we've been working on this year. We do have a list of software that has been approved by the New South Wales Law Society, and again, we use that software. There is no obligation for the law practice to use those software, but they can't use systems like Excel or Word because they can be altered, and there's no audit trail of those as well. So things not to worry about. Again, this year, I don't require a copy of your assurance reports. So that's a document between you and the law practice. So any issues that are raised in your assurance report as breaches or concerns should also be in the examiner's report. So I don't need to see copies of that. You're not required to calculate or confirm the statutory deposit account balance calculations. That's done by our office as well. If there are any changes to the law practice address or contact details, you need to advise the law practice to log those to our law inquiry form on our website. I've had some that where the EE report had no breaches at all, but it said that the address had changed, and as there was something in the final comments, it held it up, which meant that that it had to be manually reviewed. So anything like an address change of practitioners needs to be logged. The lawyer needs to log those, so they don't need to be in final comments. So I've been through the have and have-nots. Sorry, the restarting the EE reports, been through that. Now the have and have-nots, so I said that is the part where you need to make your determination whether the records have or have not. So if you get to the part, again, where it says NA, control money reports NA, then again, we need to go back and restart that again. Again, I can't tell you what your opinion is. Again, that's your opinion based on your testing and your evidence. But things like where there was 12 months of reconciliations done on the day before you turned up, that is of concern. So, and really equates to the records have not been kept properly. So that's one. So this time I want to talk about a bit more about completing the external examiner's report. So I've spoken to you about the issues that need to be included in the report, but I want to spend a bit of time this year going through how to record the breaches in the schedule on the report. So I can have the next slide, please. So this is just a manual version of what is on the LSB online. So you'll have the section number and the description of the Act. And so our LSB online will provide you with a drop-down box, and you select the rule, it will apply the section number next to it. But for example, if the payment rule is Rule 43, it doesn't give you the option of going down to the sub-rules, so say 1C, 1, that. So if you have got multiple breaches within the same rule, you can actually list them twice if you want to go to highlight different sub-rules that have been breached. The extent of the breach basically is how bad the problem is. So you may, similar to the example I said before, you may identify that the reconciliations hadn't been done. If it was 11, say, out of the 12 months, and they were all completed the day before you turned up, say that then, 11 out of the 12 on the day before my visit. If it was, say, January reconciliations not done because the law practice was shut down over Christmas, New Year and school holidays, then say that as well. And if that is the only breach throughout the year, then I'm not overly concerned about that if all of the other months have been done on time. If the breach, say, relates to receipts not being written up in a timely manner, use the descriptive words to paint the picture to me to the extent of the problem. A number of receipts, percentage, describing words, a few, a couple, receipts not written up in the time frame. So the next field is the explanation. So this is basically, in simple terms, what the law practice did wrong. So some examples of this is, say the bookkeeper resigned, changed to a new accounting system, upgraded from a manual system to a computerized one. Sometimes we've had, if there's no balance in the trust account, then it's some believe that they don't have to do a reconciliation, and that is incorrect. And basically the one that I do is they just forgot to do it. So put those explanations. And then we need to go as about what the law practice did to actually fix those problems. So for example, if it wasn't the reconciliations that hadn't been completed, they hadn't been completed, but maybe they've appointed a bookkeeper now. So again, use those describing words to paint the picture to me. So comments relating to, relating to there's no financial loss are not really relevant to trust accounting. Materiality doesn't apply to trust accounts. There's either money that belongs to the client or it doesn't belong to the client. So if there is short, it is a deficiency and it's a breach. If there's a deficiency, there's a mistake, and we don't accept that people make mistakes, then the issue needs to be resolved, reported to our office. If it's a mistake and there's money missing, money needs to be restored, advised our office. Explanations such as, they've engaged a new accounting system, the deficiency was restored. We check now bank statements every week, month. We write receipts up every day. So it's really those process improvements that the law practice wants to try and get across to you, that yep, we've had a mistake, we realise that it happened because of X, and now we've put these processes in place. If you don't believe that the law practice has taken any action or sufficient action, then say that as well. Then that will be something that I'll have a look into. So that's probably all the things I wanted to raise of concern of this year and to bring to your attention. So I'm going to pass you over to Alice, and she's going to talk about the red flags now.
Thanks very much, Christine. So what we want to talk about is the red flags that was referenced earlier on in the session. You'll see that there's a couple of examples up on this slide. These are all red flags that have been brought to our attention by external examiners in the past. What has come from those red flag notifications has been a really good preventative response from our office that has stopped the potential for these matters to turn into problems within practice management into something more catastrophic. We know that everybody has challenges. We know that lawyers are not immune from having challenges in their personal and professional day-to-day work. There's pressures, there's personal pressures, there's external pressures, but sometimes these pressures can lead to significant problems in the operation of the law practice. You are in a very unique position to be able to witness the day-to-day dealings of a law practice. That go outside the trust account recording process. It is important that we know about breaches that happen within a law practice recording system, but it is also important that we get a full picture of what might be causing systemic issues. I've got a saying that I say to my trust account investigators, which is, it's never just the trust account. Trust account problems tend to be a symptom of a bigger picture, and we'd like to know what that bigger picture could be. As the auditor, you'll be aware when you are faced with law practices that put off appointments or don't communicate with you properly, and that's probably the biggest one that we're looking at the moment. You're privy to information that we might not be privy to about things that might be going on externally. I'd like to give one example of something that's happened, which is an external examiner letting us know that when they attended the office, the roof of the office of the law practice was literally falling down. That technically had nothing to do with the trust account record keeping, but it was a very good indication that there was something going on in the office. Because we had that information, we could take steps to support the lawyer and go further from what could have been a particularly terrible time into something where we could mend the compliance issues, and the lawyer was able to rectify a lot of problems that we have. You don't have to wait until the end of trust year. You don't have to wait until there is a time for you to do the examination. We are always open to talk to our external examiners about concerns they have about law practices. That can be done with confidentiality to myself, Christine, or Shalene, or it can be done in a formal way. But the most important message is that we do want to hear from you if you have concerns. If you do have concerns and you would like to provide the law practice with some support directly, the Law Institute of Victoria has set up a practice management and trust account consult service that can support lawyers who might be having some issues. And we'll just go to the next slide for those details. So the LIV and the board have set up a program where the Law Institute of Victoria has a special consult service, one that's related to practice management and one that's related specifically to trust accounting issues and problems. These services are confidential, they're tailored, and they're done on a referral from either us or the law practice will contact them directly. An important point of this is that it is not just exclusively for members of the Law Institute of Victoria. And if you've got any problems, you can always contact us and we can provide that referral to the law practice directly as well. If we go to the next slide, we'll have the details there. So you can contact Marco and Peter. They are incredibly experienced people, but they'll be able to put our law practices in touch with the right support at the right time as well. We're also, this also includes the wellbeing support for law practices. So if they are telling you that they've got some issues that they need some support, particularly after the last 2 years where we know law practices have been under immense pressure, please feel free to use this consulting referral. Okay, so now we're at the question time. So we've got lots of time for questions actually. So if you've got any questions, please put them into our chat box. And I'll get Shalene and Christine to join me. And we'll just wait for some of these to come through. We have okay. While we're waiting for that to come through, Christine, maybe I'll get you to just refer to some of the questions that have come through prior, particularly in relation to some of the record keeping and the on-site visits.
Yeah, so again, I think as Alice mentioned, the importance of your visit, and I can see one question, surprise visits not required these days. Yes, that is correct. We had that in previous legislation, but we don't have that anymore. That's not saying that you can't. But again, any concerns, again, raised with us throughout the year. But I think the question, one of the questions is, do we have to visit on site? Again, I think as Alice said, the importance of your eyes and ears is vital to us. I understand that a lot of systems are online now. We do still have, I think from memory, about 27 or 28% of records are still done manually by law practices. So there has been increase, not as much improvement, not as much as I actually thought. Yeah, I think the question, most law practices are storing their records electronically and don't want to print them out. Yeah, I understand all of that. So again, if you are in a position to visit, it is highly recommended that you do. So that is, again, importance of the meeting with the principals, seeing who the bookkeeper is, the account staff processing, basically the accounting type process functions that you do. Where's the receipts being written out? Is it the receptionist and things like that? So you can visualise a lot of that as well. One of the other questions: how do you verify the statement is sent 30th of June? You can sometimes there will be statements with accompanying letters. These days, a lot of them are sent out by email. I know some law practices do keep copies of emails. Some systems keep copies of documents that way. Again, if you're doing it manually, you're only really trusting that the solicitor said that they're being sent out. So again, your best chance. But again, there's no requirement for you to follow up directly with the client that to compare. So like a checking of outstanding bills, you don't need to do that in regard to that. Just trying to see what else is there.
Just while Christine's looking for, just to let you know, the external examiners course is currently available. Both New South Wales and Victoria do it online. So you can do it for either state. Just need to check on the Law Institute's website for the next available course. The same with New South Wales, the Law Society of New South Wales for the next available course.
Okay, Christine, I've just seen a question about contacting us. That can be done directly. sorry if that wasn't. That can be done directly to our email addresses or through the trust group email, which we'll make available through our newsletters. Otherwise, you can make an inquiry through our website.
Yeah, and again, that is important. It's not only, I just did see one of the questions was basically, can I do the bookkeeping, GST and tax returns of a law practice? Now, depending on how your firm's set up, it's really up to you to decide whether you think it's a conflict or not. We do have some, but they are companies that are that big that they have separate, basically, arms with no overlap of the potential or perceived conflict as well. So that's really up to you in regard to that. There are, I'm not going to tell you either way as to what you think. I think that's really up to you to decide that of your own firm in regard to that.
Okay, Christine, I've got another question for you. What was the biggest trend that you saw last year of law practice breaches? It's a loaded question.
Yeah, no, question without notice. Probably the same breach that I did mention of statements not being issued. That is probably the main one. The main one of concern are the reconciliations not being done. So, we know, as Ella said, we all know that COVID's had a lot of challenges for people. We know that law practices working at home, bookkeepers were working at home, bookkeepers weren't able to get to leave their houses to go to law practices. And so those that weren't online or in the cloud, did basically suffer from that, but we do understand that. There's a difference between that and reconciliations not being done because I forgot. So these are solicitors who have a practicing certificate that allows them the privilege of looking after somebody else's money. So they have those obligations and they need to take them seriously. And so not being able to reconcile how much you have in a bank account that belongs to somebody else is of serious concern to me. So any of those ones, I will jump on straight away. So, and that's why it's important to you to tell me that just saying reconciliation's not done, because I'm not sure if that's January over Christmas or it's 12 months. So that's why it's so important if you can explain to me the extent of the problem as well.
And I think that touches on a really important point, that when we look at the big picture, if, and we're not, obviously this is not going to happen in every situation, but if we are given a circumstance where a lawyer, sometimes through no fault of their own, is in a position where they're incapacitated and somebody else has to step in to their shoes, we need to be able to understand whose money belongs to who. It's a pretty simple golden rule, and just highlights exactly how important this proper record keeping is.
Yeah. Shalene, there's a question there about if the client is closing the trust account before the 30th of March, do we do the normal online reporting? Maybe you could explain about how the final examinations are actually different to the online annual lodgements.
Yes, if they close it before the 31st, like say if you're closing on the 31st of March, we would still require both the annual and the final examination. The final examination is when the law practices authorization for trust altogether and they close the trust account. So if it's prior to, then you can do the final examination and don't worry about the annual examination requirements. However, if it falls right on the 31st or after, then you have to do both. So the final examination is a manual form that's available on our website, whereas the annual's on LSB Online. We are working towards to try and get the final examination on LSB Online, but you'll be notified once that is up and running.
Yeah, so just another couple of questions. The checklist, is it new this year? No, it's not new. Couple of little updates, but it's unchanged from last year, and it's can be accessed from our website. I was looking yesterday, if you go onto our website and just in the search function type in checklist, it will come up straight away. The lodgement deadline for air reports, we're going back to normal again, 31st of May this year again. We gave some grace to some last year because of COVID. But again, that being said, I think still a fair majority of them actually still met their deadline, which was fantastic. Why, again, it falls into that 31st of May is that I have to review these reports that you prepare. So if a report comes back all clear, no breaches, no comments, no issues at all, then it automatically clears the law practices obligation straight away. If there's anything that it needs to look up, I have to review it, and then I need to review it in enough time to make a decision on whether that law practice practitioner is fit to keep managing and running a trust account. So that's why it falls into that renewal of the practicing certificate year as well. Sorry, I'm just scrolling through.
Christine, just maybe for people who aren't familiar with the process, maybe just a little bit about what happens if happens to the lawyer in the law practice if there is a delay in lodging their documents.
Yeah, so what that things, again, I have to, normally each year I would review about 700 to 800 reports. And again, I have to review them. And it's not just reviewing that report. I also look at what you said last year. And some of my main concerns are if the issue was raised last year and in some cases previous years, and the law practice has done minimal or nothing to listen to what you said, and that might be on top of where I've done investigations as well, that then starts to put them in the high risk category as well. So I'll also have a look at what else is going on. So there could be complaint related matters in regard to trust accounts. There could be lots of irregularities, which may not necessarily be of concern, but a lot of irregularities could be just lacking in process rather than that they intend that something's untoward. So that why it's so important to get that done is that I need to be able to review those reports and make a decision. Now, in some cases, I need to do a trust investigation, need to get the investigators out before I'm really comfortable that I think that that law practice should be issued a certificate from 1st of July. So that's that time pressure situation as to why I need them in as soon as possible.
And that's the crux of the matter, isn't it? That we won't, if you as external examiners identify that there is a breach with trust account records, we won't issue a practicing certificate for the trust authorisation partner until those breaches are properly reviewed and investigated. So that can cause some stress for law practices, but we need to be very, very confident that people who are dealing with trust money are authorised and competent to do so.
And again, it shows, and that's why what that field about what has the law practice done. So, things like where they may have had, and I have had over the last couple of years, a few of concern, and they've tried to do the bookkeeping themselves. But again, I'm an accountant. I'm not an expert in legal matters. So, and some lawyers have got accounting backgrounds, but some don't. So, it's knowing where your lane is. And if you can't do it, or some people have got time pressures, families, studying, lots of other things outside that can affect your time. So if you can't do it yourself, then you've got to be in the situation where maybe you look at putting a bookkeeper in. So the fact that they're taking a positive approach to engaging a bookkeeper or engaging a new computer system, and there's, no, I'm not saying there's any obligation to be to go out and spend tens of thousands of dollars on a computer system, but those changing processes and procedures and those efforts that are made are what I want to see going forward. And so in regard to that, if I can see improvements are being made, I may do a trust investigation, but still be happy to allow the practicing certificate to go through. But ones I'm certainly not concerned on, certainly concerned with where there's been no improvement. And I have had a few where the examiner basically said in the final comments, there has been no improvement from last year or the year before. And I've got to take those seriously, and then that will mean their certificate will be stopped until we get to the point where I'm satisfied. We do have a few options available to us if we can't, if we don't see any improvement. So, the first thing we do is suggest that you get a bookkeeper, and I know that is, financially onerous for some people. So, but the point, if we get to that point, we can do basically what we call management system directions, where we're directing the law practice to say, engage a bookkeeper, and the bookkeeper may be one that we've approved. So that is a specialist in law practice accounting. So it's really a lot of that stuff is what I look at is what's happened. Has there been improvement? And I'm happy to, absolutely happy to see if I see improvement on them. I'm really happy. I'm certainly not out to get anybody. So any improvement is fantastic to see.
I could just say another question here, and I think you answered it before. There's a situation where, the simple answer to this, the question is, do we need to record all breaches? The answer is yes, unequivocally. What we do with that information, I think, is more of the question. And Christine, I'll let you talk to this, but I think we agree that there are some areas that are a bit, that the lawyers might say something different about whether or not it is a breach or not. It is your opinion. It is your judgment about whether or not there is a breach. We will make the decision whether or not it requires a response. Do you think that's an accurate assessment of our
Yeah, absolutely. I mean, we absolutely accept that people make mistakes. There's no thing. I mean, we used to have, which tends not to happen as much now, is that somebody would pick up the wrong deposit book, because all the deposit books used to look the same. So they'd have an office account, deposit book, and then they'd have a trust account, and they'd look identical. And so, things like that don't tend to happen as much now, because we've got, a lot of stuff's done by EFT. So, but, where there's a genuine mistake, don't say, we don't have a problem with that. And so, yet we realise that, the receptionist was picking up the wrong deposit book. So we put a, red tag on the trust one and a green tag on the office one or something. So those proactive steps to take that. But again, so anything like that are genuine mistakes, and irregularities where you have clients making mistakes. So we'll have a client that may have paid you money up front, or may have paid solicitor money up front as a deposit. So the next time, so a bill's been raised and maybe they have to pay the bill, and that's, once the work's been done, then it's not trust money anymore. But the client may just pick the last account, which you tend to do in your internet banking. You just pick the last account number that it went to. So you may find that the client's paid into trust instead of office, and vice versa. I mean, that's nothing that law practice can control. So, we have where we categorise the trust irregularities. So we'll have a client error, a bank error, and we know banks make mistakes as well. And then we'll have the law practice error, and it's the extent of the law practice error of those mistakes as to how far we will look into. And again, if you have, we may have lots of notifications of irregularities, of constant mistakes being made. So it's not about that their money's being stolen. It's just that we need to improve it. The law practice needs to improve their processes. So with that, I'll just see if there's anything else. And lots of questions now. We won't be able to answer them all today. So again, we'll do what we did last year, which was collate all the questions together, and I think we have had some via email as well. So we'll collate all those the questions from the Q&A together that we haven't answered, plus those ones that have come via email. And I think last year we put them on the website, Shalene, or distributed.
Yes, we did. Yeah. Yes.
So probably the last one I'm starting. Is it mandatory to have a computerized accounting system? No. So as I said, we still have probably 25-26% of practices that have use manual records. So the LIV have a bookshop where law practices can go and you've probably seen the pre-printed software. So there's pre-printed receipts, cash payment books, cash receipts books, journals, ledger cards, reconciliation forms. So there's no obligation at all. If we've got law practices that might have, 1 or 2 transactions a year, and that's it. So you certainly wouldn't, or they certainly wouldn't, unless they use the computerized, say a computerized law practice system, and the accounting module is one part of it. So that might be the case where you may get a smaller firm use that, but they use the software, say like Leap or other packages have precedents set up, letters, file management, things like that. And the accounting module is just one part of that. So if they're using it for that, they might that. But then we've also got some where they'll use a system, but they won't use the accounting module. They'll use manual systems, even though they run a computerized law practice system. So, but as long as it is used on probably not say the LIV software, but just not Excel or Word. So with Excel and Word, as you realise that they're you can delete transactions, you can modify transactions, there's no audit trail. So these accounting systems that there's probably about 15 off the top of my head Shalene, if you'll remember me.
Yes.
They all have those basic accounting functions in the back end. So they've got audit trails, sequential numbering, can't delete transactions and things like that. So the other thing is, so MYOB, QuickBooks, things like that, not to use those either. So they can be, and I use them myself, they can be altered. You can delete transactions. There's no sequential numbering. They're not set up for law practices, law practice trust accounting like that. So, but yeah, so yeah, don't force it. We certainly wouldn't force anybody to spend a lot of money as long as they're complying in whatever way suits their practice best.
Okay. Well, thank you, Christine and Shalene, for your expert knowledge. That kind of gets us to time. What I'd ask all of our external examiners who are here today is while you're finishing up this, do take the time to go onto our website, have a look at what we do in the bigger picture. You are a very important piece of a puzzle. We are very much moving towards our goal of being a proactive, intelligence-led, data-based, risk-based regulator. To be able to do that effectively, we need all the information that we can get, and you are such an important part of that puzzle. So I would encourage you to take the time, see what we're doing in other areas of the organisation, see how we communicate with our law practices, see how we communicate with people that engage law practices, and really understand that you are part of a very big picture here that keeps the profession reputable and keeps consumers safe and their money safe. So again, I thank you for your time. I thank you for all that you contribute to us. And if you have any questions, thoughts, or even insights on how we could do our job better, please don't hesitate to reach out to us. If anybody's got any particular questions about this course or anything that we can do, you can contact us through the channels. We do intend to have another newsletter in the next couple of months that'll include this recording, and we hope to engage with you a lot over this end of trust year period. So again, thank you very much for your time and your patience. This is obviously my first time of doing this, and so thank you for indulging my stammering and general nerves at being the face of this really important project. And I'd just like to extend my very sincere thank you to Shalene and Christine for the wonderful work that they do in this space as well. And I will finish it up on that. Thank you.